Right, well, the subject of this session is human rights and religious freedom. The speakers are Carolyn Evans, who is the Dean of Melbourne Law School and a well-renowned expert in religious freedom. She's the author of Religious Freedom under the European Court of Human Rights, published in 2001, and co-author of Australian Bills of Rights, and co-editor of Religion and International Law, Mixed Blessings, Laws, Religion and Women's Rights in the Asia-Pacific region, and Law and Religion in Historical and Theoretical Perspective. The second speaker is one of the co-organisers of the conference, Farah Ahmed. She is Senior Lecturer in Law at Melbourne Law School. Before this, as I know well, Farah was a tutor in law at my college in Oxford, namely Queen's College, and her areas of specialism are legal theory, public law, multiculturalism, law and religion, family law and South Asian law. And she has studied both in Delhi and in Oxford, including work on religious freedom. So I believe that Carolyn is due to speak first.
Thank you, Nick, and let me start by acknowledging my co-author on a much larger piece that this paper is a small segment of, Timna Baker. Religious freedom in many ways can seem a paradigmatic example of a right. It's found in numerous constitutions around the world, including some of the great founding constitutions, in international treaties, in declarations. If people are to say off the top of their head a number of rights that you might see as human rights, it's certainly one of them. And yet, the inclusion of religious freedom, particularly the right to change religion in the Universal Declaration, was contested at the time. And in coming decades, a series of ever more complex questions about whether there should be such a right, what its legitimacy is, and particularly what its scope is, has arisen. On one hand, there are two broad groups that simply deny the importance or relevance of the right altogether. On one, people who believe that they belong to the one true religion, whatever it is, that there is no need to yield any ground, any rights to false religion above what simple tolerance or prudence might require. There is no right in error, as the old mantra of the Catholic Church would have it. On the opposite side, people who say, well, religion itself is now inherently unworthy. It's subverting of social good, and they're largely hostile to religion. So while we might, again, as a matter of prudence or necessity, need to yield some ground to protection of religion, some strong form of religious freedom is not something that we should aspire to as a society. In addition to those who are dismissive of the importance of religious freedom, however, there is now, I think, stronger contestation as to the scope and the meaning of religious freedom. So there are those who claim that they are committed to religious freedom, it's a very important right, but who conceive of it in very different ways to the orthodox liberal version of religious freedom, with its emphasis on the individual consciously making choices between a range of religious options. A notion that I think is really in many ways a sort of Protestant European post-Reformation notion. In this paper, I want to explore those tensions through the lens of proselytism and conversion and the laws that seek to regulate them. I'll outline a way in which different conceptions of religious freedom lead to quite different approaches to the legitimacy or otherwise of these laws. And by way of case studies, I'll focus quite briefly on Malaysia and even more briefly on India. I believe that there are legitimate questions as to the conception and scope of religious freedom that are being raised by the non-Western world, particularly in Asia, in a way that's challenging to Western conceptions of religious freedom, but that may ultimately make it richer. But I also want to warn of the danger in the way in which some majorities can co-opt the language of vulnerability and minority-like status in order to claim certain protections and privileges with respect to religion, while simultaneously claiming the democratic benefits and prerogatives of being a majority. Let me start with an extremely brief conceptual debate, far too brief for the complexities here. The beginning point for most courts in Europe, North America and Australia and so forth as to whether someone should be allowed to change religion or encourage another person to change religion is from the point of view of the autonomous, self-defining individual, the classic liberal starting point. Religion is just another choice, an important choice, but just another choice that an individual can make. To accept religion, to reject all religion, to change religion, to modify religion once, multiple times over a lifetime. It's a decision which is intensely personal and not for state interference. And just as a political party may make arguments to secure an individual's vote, or shopkeepers may advertise to entice him to exercise his power of purchase in a particular way, it's perfectly legitimate for various religions to encourage him to convert to their belief or to dissuade him from trying to convert to a false or untrue belief. In this conception of religious freedom, there really are no legitimate constraints on conversion, and the only legitimate constraints on proselytism are to prevent the subversion of free will, for example, prohibiting the use of threats or fraud or coercion. Though, as we'll come back to, that's a little more complicated than it initially seems. However, other conceptions of religious freedom are increasingly challenging this traditional way of approaching issues like conversion and proselytism. One that's had influence in a number of Asian countries in recent years is a much more communal concept of religious freedom. Religions are not primarily about the individual, but primarily about communities. Not uncommonly, predetermined communities entered at birth, defined by a range of characteristics, religion sometimes only being one, not uncommonly ethnicity, for example, being another. Religious freedom under this conception is about allowing each group the space that it needs in a particular society to continue its traditions and beliefs. Its underlying rationale can be as much about intercommunal harmony as religious freedom per se, which of course was also the root of the European acknowledgements of limited religious tolerance after decades of religious war. Such an approach acknowledges that if one group is too persecuted or ground down or offended or inflamed, this will cause tension and ill will between the groups, and thus religious sensitivities and practices need to be protected. In this scenario, the individual bent on changing religion or encouraging others to change their religion can be seen as a threat. Laws to limit conversion of proselytism become justified because of concerns about the ill will between different groups that can be caused by attempts to attract other group members. And this can be so, and sometimes quite differently in the same country. So people living in a small village where people do a lot of things together in the same way, where religion is part of day-to-day life, may feel this much more acutely than people living much more anonymous and autonomised in the same country lives in the city. Without this becomes particularly acute in countries, and Farah may go on to touch on some of this, where we have communal religious laws for different groups. In those circumstances, a converting individual might be seen with suspicion as somebody trying to evade the disagreeable strictures of the laws. Somebody who wants to drink alcohol when their community law wouldn't allow it. Somebody who wants to marry a second wife when their community law wouldn't allow it. In these circumstances, even personal decisions to convert can be challenging to the intercommunal status quo, and in this conception can be legitimately regulated, for example, through the requirement to register formally changes of religion. Proselytism can be constrained, or severely circumscribed, sometimes even banned, particularly if there's evidence that it will cause intercommunal tensions. But there's another variation on this communal conception of religious freedom, which begins to use the same language but veer towards outright rejection of the fundamentals of religious freedom while co-opting its language. That is the use by a dominant religion of the language of religious freedom to justify imposing the full extent of its understanding of what's required by its religion on the whole of the population. Religious tolerance, rather than freedom, is whatever the majority chooses to extend minority religions, whether out of benevolence or a wish to keep the peace. Any suggestion that this is repressive or unfair to minority religions is met by a vigorous argument that any such restrictions on the majority's group right to impose religious laws is both undemocratic and a breach of the religious freedom of the majority. I'd like to look at two case studies now. I'm going to start with Malaysia, which I'll talk about in a little bit more detail on the assumption it will be less familiar to most people here. As many of you I'm sure know, Malaysia is a multi-ethnic country constituted by a majority of Malay Muslims, and the Malaysian constitution says as part of the constitution that to be a Malay is to be Muslim. A sizable minority of Chinese, who are usually Buddhists or Christians, and smaller Indian, Hindu and indigenous peoples.
Well, ladies and gentlemen, thank you for being here and for being such willing participants in this conference. My topic is constitutional comparison between India and Australia. And despite that somewhat grand title, I don't in fact intend to attempt full-scale substantive comparison between the constitutional arrangements of these two countries. That would be a huge and probably rather boring task, and one for which in any event I'm not equipped, at least as far as the Indian perspective is concerned. So instead I want to take the opportunity to use the comparison of the constitutional arrangements of India and Australia as a case study in the methods of comparative constitutional law, its pleasures and its pains, or to use another discourse, its opportunities and threats. And to this end, I'll use it as an example, one aspect of the constitutional experience of the two countries that potentially lends itself to a comparative project, the presence of a basic structure doctrine in India and its complete absence from Australia. That example I choose partly because it currently has considerable contemporary relevance in various parts of the world, but it also refers to an aspect of the Constitution of India about which I'm very curious and I would like to know more. Now, my motivation in treating the topic in this way is really to indulge my own long-standing fascination with the realities of comparative constitutional law in the face of the often sweeping generalities that we encounter in the field. This is a time of considerable interest in these matters, which also reveals considerable disagreement about exactly what comparison now involves. In a sense, that disagreement isn't new. There's a long-standing divide between comparativists over the transferability of legal concepts from one jurisdiction to another. There's long-standing disagreement about whether the goals of comparative law are, or should be, or even plausibly can be, a search for the best system. And there's deep divisions between comparativists about how best to allow for whatever contextual variations exist in the legal arrangements that they propose to compare. But difficult though these questions may be, the goalposts have been shifted in this debate by the impact of internationalisation and globalisation in all their manifestations as forces for apparent universalism in both a descriptive and a normative sense. And the position of sceptics of that position is sometimes weakened by the pejorative connotations, sometimes attributable and sometimes rightly attributable to claims of local difference. We saw that most notably in the course of the Asian values debate a decade or so ago. We can also see that sometimes there are pejorative overtones to claims of exceptionalism, particularism, localism, and so on. Now, there's no doubt that this is a time of change in the configuration and operation of the constitutions of the world. It parallels in many ways the changes in the interdependence of states. It's sometimes described as global constitutionalism or occasionally the internationalisation of constitutional law, and it's by no means clear where all of this ultimately will lead. But exactly where we've reached now and what that means for comparative constitutional law now is very elusive. The range and penetration of international and supranational law undoubtedly has expanded. There has been some convergence of the whole gamut of constitutional phenomena across national boundaries. General principles of constitutionalism, the institutions of government, constitutional text, judicial interpretation, constitutional theories. And the ready availability of constitutional data now encourages large N quantitative research that necessarily downplays qualitative difference. But internationalisation is not even, and nor is it linear. It affects different states differently, and it ebbs and flows over time. Convergence in any event is always only partial. A bit of text here, an institution there, a dash of constitutional theory and somebody else's particular interpretation. But once those things are all mixed together in a new constitutional system, the results can sometimes be unexpected. The context in which constitutions work in any event continues to differ. And there are all sorts of forces for diversity as well, including the expressive function that constitutions necessarily play if they're going to work in a local context at all. Now, I could continue to identify these contradictory forces, but I promise you I won't. I hope that I've said enough to show that there is evidence to support a range of different opinions on the state of global constitutionalism and its implications for comparative law. These stimulate lively debate in what is now a very vibrant field, but they can only really be tested by their application in concrete settings and by discussion between those who know. Now, the constitutional systems of India and Australia provide a fascinating case study for this purpose. On the face of it, literally on the face of it, on the face of the texts, they have many similarities. Both of our countries have written entrenched constitutions enforced through judicial review. Both are constructed on the constitutional principles of representative democracy, federalism, separation of powers, judicial independence, although I completely agree that we must allow for considerable variation in what those terms actually mean. Both of the countries have bicameral parliamentary systems along Westminster lines with largely non-executive heads of state. And both are embedded in common law legal systems with all that implies for the similarities of legal principle, remedies and other legal concepts, for the design and structure of the courts, for the forms of judicial proceedings and for judicial reasoning. But the differences demand attention as well in any comparative exercise. Most obviously, even on the face of the Constitution, the Indian Constitution protects rights, whereas the Australian Constitution does not. This difference goes well beyond the manner of rights protection itself. It affects the focus of constitutional discourse, and we've witnessed that in the roundtable, in the workshops over the last few days. It feeds into the modes of judicial reasoning, and it has relevance to the weight borne by other constitutional and legal doctrines, including the separation of powers and administrative law, on which so much of Australian public law depends. More challenging still are the other, even less obvious differences, which are not necessarily evident from the constitutional text, at least without the forensic skills that Gunther Frankenberg's work on the architecture of constitutions urges comparativists to use. So let me suggest just a few of these. The constitutional history of the two countries is very different at all critical moments in time: pre-colonisation, the colonial experience, independence, post-independence. Thus, for example, to take only one of those, while the Constitution of India was made by a constituent assembly coincident with the moment of independence in what Europeans would call the Big Bang moment, the Australian Constitution was enacted by the former colonial power, preceded independence, which in any event was a long, drawn-out affair. In consequence of that history, different influences have been brought to bear. The Australian Constitution is a relatively simple mix, by comparison with India, of the British and American influences. India also is influenced by those states, but through the prism of the Government of India Act in the case of the United Kingdom, and with other very interesting influences from, for example, the Republic of Ireland. And the constitutions dealt with different challenges. The Indian constitution is a transformative constitution, as we've discussed a lot in recent days. The Australian is very structural, very pragmatic, and those two characteristics also feed into the styles of judicial reasoning. And then there must be other contextual differences that lie more deeply still. The legal, linguistic, and religious pluralism of India contrasts with the relative perceived simplicity of Australia on each of those fronts. The vast differences in population size dramatically affect the operations of the constitutions in practice, in ways that range from the conduct of elections to the management of the caseload of courts. And the geographical and geopolitical positions of the two countries feeds into a range of constitutional differences, including, I suspect, the views of the respective apex courts on the applicability of international law. Any of these differences, and others that I'm sure you can think of, may prove relevant in a comparative exercise involving India and Australia. Now, how they come into play can be illustrated by any one of a number of comparative projects. From my own perspective, there are several current constitutional problems in Australia for which India is a very tempting comparator. One is the question of the scope of inherent executive power, the circumstances in which the executive can act without legislative authority, which is an issue with which our High Court is grappling very seriously at the moment. Another, somewhat more esoteric, is the extent to which the centre and the states can confer administrative functions on each other, an issue on which the High Court of Australia has already cited the Constitution of India. And it may well be that from an Indian perspective, there are insights to be gained from Australian practice in relation to, for example, aspects of the separation of powers, including mechanisms for the protection of judicial independence. The project that I propose to use, however, is the very topical subject of the acceptance of the possibility of unconstitutional constitutional amendments. Now, this is a very hot topic for global constitutionalism in the second decade of the 21st century. The notion that a constitutional amendment might literally be unconstitutional is spreading, at least as an argument, to states where it has not previously been considered before. New constitutions are beginning to adopt so-called eternity clauses. Judges interpreting older constitutions increasingly are faced with claims that the proposed amendments violate a basic constitutional structure. But not all states have gone down this path, and there is burgeoning interest in how to explain or even to predict where a basic structure argument is likely to be accepted, or perhaps where it should be accepted, and where it is not, or perhaps should not. Now, India, of course, is the home of the basic structure doctrine in its judicially constructed form. But Australia does not accept the possibility of unconstitutional constitutional amendments and is highly unlikely to do so. The two states thus appear suitable comparators to explore this issue further. At first glance, a plausible hypothesis is suggested by differences in the amending process in the two countries, in both form and operation. In India, amendment is relatively easy, frequently achieved, and effected through elected representatives. In Australia, amendment is difficult, rare, and involves a popular referendum. Comparison of the two therefore seems to support an emerging view that a critical distinction lies between states that have relatively easy amending processes with no element of direct democracy, and states where amendment is difficult and involve the people in some way. At least as the sole explanation, this hypothesis is fairly easily shaken once other states are added to the mix. South Africa is an obvious example. But even if we stick with the India-Australia comparison, there may be occasion to dig a little deeper. In principle, the very conception of an unconstitutional constitutional amendment involves the notion that a higher constituent power has prescribed the essential framework of the Constitution from which those with mere power of amendment are enabled to depart, the implication being that if you want to do that, you have to go back to the constituent power. This way of approaching the problem also ought to assist courts in determining the elements that constitute the basic structure in the first place. On this basis, if that's right, another relevant difference between India and Australia may lie in the engagement of the constituent power in the first place in India, and thus in the very way in which the Constitution was made. Now, I don't know whether that explanation has salience in India, and I'd be really interested to hear from you on the matter. If it does not, I would say that the basic structure doctrine as it operates here is a very interesting example of a transplanted constitutional concept without its underlying theory, leaving the theoretical underpinnings to be locally devised, which itself is a source of latent diversity. And even if this is accepted as a relevant factor, it seems to me that it's unlikely also to be an explanation that is sufficient in itself. Also relevant to comparison for this purpose is the extraordinary role that the Supreme Court of India has carved out for itself in its own complex relationship with the other branches of government in India, apparently with widespread acceptance from the broader population. Now, no doubt it's apparent from these brief remarks that while I'm very conscious of the movements in global constitutionalism, I remain convinced of the reality of difference, curious about its causes and about how and why it persists. Even where differences are relatively minor, they're often the stuff with which lawyers work in any event and not to be scorned for that reason. And to ignore comparative difference is not only sometimes to reach misleading conclusions, but it's also to waste the potential for drawing on a wider range of constitutional experiences to resolve the constitutional problems of the countries of the world, which are by no means settled by existing constructs. India and Australia make excellent comparators for exploring these problems of methodology. They have enough in common to make comparison practicable and productive for any of the purposes for which it commonly is used. But there's also enough underlying difference between the two constitutional systems to make comparison a genuine, intellectual, research-oriented challenge. As always, it's very difficult for an outsider to fully understand the nuance that lies between the form and operation of someone else's constitutional text. And this is one of the many reasons why I'm delighted to have had the opportunity to be here for the last 3 days, to gain a better understanding of India from those who really know. Thank you.